welcome to today's episode of Your Business with Accent Nominees. My name is Daniel Olukayode Adeyemo, and today we'll be looking at investment agreement in business guides for startups. So last week we looked at the legal implications that comes with applying for bank loans, and generally the whole concept just revolved around finances, right? We cannot but admit to the fact that finance or money or cash or capital contributes. It's a major thing when it comes to running a business, either at the beginning stage when you're just starting out, or even at the point of expanding to other territories of the world, right? So today we're looking at the investment agreement, and investment is another way through which you can get funds, sorts of funds, in order to finance your business. All right. So and when we talk about investment, it's more or less like you would need an agreement. All right. So ordinarily, what you need to do is to try and source for investors that you can convince that what, especially if you're just starting out, that this business idea is a great one, is going to yield you huge returns, blah blah blah. You just convince them. But once you're done convincing them and they agree, okay, let's get into this, you would need an investment agreement, and that agreement basically would outline there are different there are different key terms in that agreement. So it usually outlines the rights, the liabilities, the responsibilities, the obligations, all of those things, even basic things such as your name, your address of the parties, and all of those things. So you need to have all of those things in place. All right. So, and one thing you should also know is that investment could go beyond money sometimes, right? Yes, a person is coming, okay, I'm going to financial business with so amount of money. They could say, you know what, other than this money, I will be providing communication services. I'll be providing, maybe tangible assets like landed properties, or use this building, or all of those things, right? So it doesn't necessarily have to be money, but money is a main, is a main feature when it comes to investment agreements. All right. So like I said already, once you secure your investor, you need to have a well-drafted agreement. This would go a long way, in helping you building that relationship that is about to commence. All right. So talking about key terms of an investment agreement, which I already mentioned already: the name and address of the parties involved, the signatures of the parties, which shows that we agree to be bound by this agreement. Other specific things such as the exact amount the investor wants to put in, the exact date the transfer will be made to the company's account, the length of time the investment agreement would last, because there's no investment agreement that just goes on and on and on. So it's usually specified. They will say, okay, this is a 5-year investment agreement, this is a 4-year investment agreement. All right. So within that period, the relationship would go on. So it is timed. All right. The return on investment, if it's a percentage of something, depending on what you agree, it is stated specifically. All right. And that's that on that. Let's look at the attracting investors. So today's topic, we're looking at guides for startups in terms of investment agreement. But like we already mentioned, before you even talk about investment agreement, you even need to even get those people that you want them to invest in your business. You need to attract them. All right. So in attracting them, there are a few things which I would just term like business management 101. There are things you should put in place, because nobody, including yourself, if you're going to invest in a business, there are certain things that would want to kind of encourage you to go ahead and invest, and there are certain things that would just turn you off immediately. That no, I think my money will be used for Sarah, quote unquote. So now it's very important that certain things be put in place on the part of you as an entrepreneur, on the part of myself as well. All right. So one is a credible business plan, not just a business plan, a credible business. A credible business plan. All right. So what we're saying is that your business plan will contain certain ingredients, all of those things that are needed, in such a way that once you present it before an investor, the investor will say, okay, this is cool, let us move on the relationship, let us enter into an agreement. So your business plan would usually contain the executive summary, evidence of the market research you've done, your competitors, what you've seen about them, what are your predictions, all of those things would be in your in your business plan. Sorry. Now it's also expected for you to know your numbers. Now it's, when you're dealing with investors, you will need to make them know that, what, I know what I'm talking about. I've done my research. This one is kind of like flowing from the part of the business plan. So you need to know your numbers. You need to have a solid understanding of your business model. That is, how will money be entering? Is it subscription basis? Is it this? Is it that? All of those things must be put in place. You must be able to predict profit by virtue of your market research, which you've done in your business plan. All right, you must be able to say, okay, within this social period, we'll get certain percentage of this, of this, of this. So you need to have all of those things intact, because these are the things that investors are looking out for firsthand. All right, a detailed structure of how your business would spend the investment which you are seeking to get. All right, so a detailed step-by-step process. So we're going to put money here, we're going to get this, we're going to buy this, we're going to invest in this. So that's how it basically works. You should also ask for the right amount of investment, because that has shown, or it has been proven over time, that when you approach an investor, you could make the mistake of asking too small or asking for an exorbitant amount, in terms of investment. Now I'm using money as a major example because it's the main example we can give here. So you need to actually ask for the right amount, and before you can even ask for the right amount, first of all, there's a major thing which we'll be looking at, long time from now, short time from now, and that is the need to have an advisory board. So I won't go deep into that, but in terms of asking for the right amount of investment, of course, you need to look at what you're setting out to do. All right, so you need your advisory board here to actually advise you on what to do on the, looking at the project before you and the advisory board. You'll be able to look at, okay, we'll be needing this amount to cover for, since we're just starting out. So all of those things, not that you just come up with something and just say, what do you think we should actually even, let's request for. No, you don't go about it that way. So everything is planned, because at the end of the day, you're going to state what you intend to do with it, how you intend to go about it. All right, because when you ask for too much without detailed analysis, without research, or when you ask for too little, it could kind of like spoil red flags, on the part of the investor. Because let's face it, it's a business. You're doing business with the investor, because at the end of the day, the investor is giving you its money, or money. It's money if it's a firm, right? They're giving you their money, and you're using it at that point to solve your immediate need of your startup, and then you're also getting profits. They are also getting, what they call it, they're also getting return on investments. All right, and I didn't mention this earlier. The returns could be in form of equity in the business. It could be a certain percentage of profit at a specific date that you've agreed upon. It could be voting rights. It could be management rights, and all of those things. We'll be looking at a few of those things subsequently, very shortly. All right, so another thing is that you think like an investor. You think like an investor, and what you do is that you try to imagine what are the possible questions you can actually even ask me, and then you try to give credible answers to those questions. All right, so you think ahead, you think like them, stand in their shoes. Another is to master the elevator pitch. So whomever your investor may be, or your potential investor that you look up to, faith can bring you, faith quote unquote, can bring you such that you meet the person somewhere, and then you have the opportunity, or within a short period of time, to pitch your business idea. If it's just a startup, right? To tell them what it's about, and that this is where it is advised that you master your elevator pitch. Elevator pitch, I believe we are familiar with it as business people already. So you just have to have something like a 1 minute or 2 minutes, 3 minutes max, 3 minutes, just a breakdown of what you're doing, what your startup is about, and your ability to capture that investor at that point goes a long way. So it's when you're even able to capture the attention that you can talk about, oh, okay, let's see other things which you'll also be looking at, and then before you now proceed into the investment agreement, which is kind of like the main discussion for today. All right, so another is to have your books. There's several series ago, and if you check out our Facebook page, you would see where we actually spoke about something related to the need for you to keep your books and all of that. The major books, the balance sheet, the profit and loss account, the income statement. Those are the things they look at. When an investor agrees, okay, you did the elevator pitch, fine. the person wants to see you, the person agrees to meet you, and then you, of course, you need to produce some of these things that I already mentioned, the business plan, all of those things. Your books, for example, this is what we're talking about right now. If you don't have a complete book, it's a put off. It can put off, the potential investor. So you need to make sure things are in place. Make sure you follow due process. You have everything in place so that it favors you in the end. All right. So this is mainly like a preamble to what we're discussing today. All right, so we've looked at a brief introduction, key terms in an investment agreement, then attracting investors, the things you need to do. All right, so now before you can talk about protecting your business from investors, all of these things have to be in place, because no investor, even I as an investor, I won't approach you if some of these things are not in place. All right, so now talking about protecting your business. So at this point, let's say you've done all that needs to be done. The investor is interested in putting a certain amount of money or giving you certain tangible property assets, or providing you certain services, right? So what do you now do to protect your business? Because in time past we've had situations where you see or you would hear that a founder of a particular brand or a particular business or startup, he actually he got an investor to come on board, and then the next thing is that he's outside of his position as the founder of the company. In other words, he's sacked, or he loses control over the business. We've had this over time. All right, but then there are also ways to prevent all of these things from happening. All right, so we need to understand that our due diligence, prior to entering into the agreement, prior to creating the agreement, as well as our negotiation during the course of that agreement also matters. All right, so we need to pay solid attention to all of this. Also, you need to be observant. This is more like a natural thing. Your perception of the investor you're bringing on board. Do you think this person is the kind of person that would act in good faith in every situation? Do you think this person doesn't feel like extra ambitious and can house me of this position? These are things that will inform your decisions. All right, in terms of what the terms that will be contained in your investment agreement, as well as major decisions you'll be making. All right, so let's pay attention to the following things. One, you need, like I mentioned before, you need to appoint an advisory board. So for startups just starting up, right, it is very important, before you even talk about having a board of directors, all of those things, at the very early stage, you need your advisory board. These people, they're instrumental to the success of any startup just starting up. All right, so for me, as within the scope of what we're discussing, the advisory board will usually ordinarily contain people from diverse professional backgrounds that will be able to provide mentorship, in terms of should I say, the kind of people you hire, and all of those things, right? They would help you in all of the, especially within the range of what we're talking about. Remember, a few minutes ago we talked about the fact that they help you with deciding the amount of investment you think will be suitable for the project you're about to embark upon. All right, so these people, they fill knowledge gaps, they help, and you can't just do without them. All right, so in practical situation where an investor, you've notified them that, okay, we have this investor from so. All right, they can look into it and say, they can give you credible advice on, oh, okay, I think this person is great, we can go with him, or I think no, let's look for someone else. So this is the place they feel, all right, in ensuring the overall success of your startup. All right, so also we have partner participation rights. This one is even more critical, especially when we talk about the issues of the founder of a business being fired from his own business, all of those things. So one thing that happens is here, generally in investment agreements, the investor will usually have the upper hand, but we'll speak about this towards the end. All right, so this is why it's very important that negotiation goes on. You negotiate all the terms. Now, speaking about partner participation, in your perception, once you observe the investors, you see that, oh, okay, or maybe the advisors advise you together with your own perception that, oh, I think this is a great person, or this is a great firm, they have good intentions for our brand and all of that. You can choose to, it will determine the level of, should I say, the level of rights they would have in terms of participation Maybe they could have full participation or partial participation or no participation at all. All right. So I said something about upper hand because all of these terms at the end of the day, if they're not fine with it, they may not sign it. All right. So, but then you need to also ensure that your company is safe. You're not at the risk of losing your company at any point in time. All right. So the non-participatory rights, the partial participation right, or the full participation right will depend on how you've observed, how the advisory board has looked at it. Oh, I think this person is a great person. Let's give him partial participatory right or participation right or full, or depending on it. All right. But one thing we should also pay attention is that this also applies to voting rights, because there are certain decisions you need to make that voting will be required, and you need to be careful about the percentage you give to these people. All right. It has to be such that it favors you as a founder of the startup. In a situation where you go ahead and give them over 50%, in your business, at the end of the day, they can oust you. At the end of the day, it's like you don't really have a say, at the end of the day, so which doesn't favor your business. And these are some of the things that have caused situations where you see people that founded the business and then they're out of the business and then the investor is in control. All right, so you need to ensure that you put all of these things in place. So no clause should give the investor unnecessary control over decision making in the company in terms of voting right and all of those things we already mentioned. All right, so let's move on to the escrow clause. We call it escrow clause. All right, so what this one is saying is that they are within the context of investment agreement. When the investor is going to advance money into the account, so there are certain liabilities, there are certain terms that guides how money is to be advanced. Of course, when you're talking about advancing money, we said it earlier that the amount has to be specified. The date is going to be also specified. All right. So escrow clause is saying that let us provide an escrow payment facility. Let's say an escrow account. That the money intended to be passed to the company's account will be paid into that account. Once the terms are there to, at the date it was already agreed that the payment will be made. The payment will be moved from that escrow account to the company's account. So where the investors fail to adhere, of course, in order to preserve the relationship, you'd have to opt for ADR, and if the worst comes to the worst, you'll be looking at litigation. All right. So the whole essence of this is that there's an escrow account where the money is paid into the agreed investment amount. Once terms are in line, are adhered to, on the specified date, the amount moves from that escrow account into the company's account, not your account, the company's account. All right. So we also have the indemnity clause. The indemnity clause. The indemnity clause protects both parties, and mind you, everything we're discussing today is in line with how we protect the startup, not from the point of view of the investors, because we've had situations where investors too have been victims of, misrepresentations on the part of a founder of a startup saying, okay, we're going to do this, we're going to do this, and then at the end of the day, they did not favor the investor. But today we're looking at it from the perspective of a startup, a founder of a startup. Alright, so the indemnity clause is used to protect the founder from losses that comes as a result of where an investor fails to make do with their promise. We're going to put in a certain amount of money, and then probably the founder goes on and acquires certain things to do this. With the thought that this investment amount is coming in, we're going to be able to put it to settle all of those things. And then the investor did not do anything about it, did not make do with the promise that has been made. Alright, so in a situation like this, the indemnity clause seeks to indemnify the founder such that whatever loss has been made because of the failure of the investor to make do with the promise will be borne by that investor, so they won't lose anything. All right, so the investor would have to bear the risk, the responsibility, the liabilities, all right, the losses that comes with that failure to adhere to the term, the indemnity clause in the investment agreement. All right. So we also have the non-compete clause or non-competition clause. All right. So this one is saying that an investor should not, after signing an agreement, that investment agreement should not delve into other business arrangements or other agreements that competes with that investment agreement I signed. All right, so that is what it states, because this in itself can harm the business. It brings about dividing loyalty. It's impossible for him to be loyal to two at the same time, so which could hamper the business, because by virtue of the agreement they are privy to a lot of details, they are privy to a lot of should I say trade secret and all of those things. So all of things could clash, trust, all of those things. So this is an important clause that can help you as a founder of a business when trying to you know enter into a relationship with an investor. All right. That is that for non-competition clause. We also have the non-assignment clause. Uh, non-assignment clause is saying that an investor that is coming into this business to advance a sum of money and probably get a particular equity in that company. What this one is saying is that he cannot transfer that equity, that share he has, the shares he has in your company. He cannot transfer it to another without your knowledge and consent. So this is what this one is saying. He can't just, on its own volition, just say, I'm transferring this. No, and such will remain for the period of the investment contract. You can state that, till the end of this investment contract, you cannot, transfer this right you have to another third party or to another person. All right. So there's more to this also, though. All right. So we also have representations and warranties. So this one is kind of tied to the indemnity clause. So this one is saying that the investor will state, and mind you, this clause also applies to the founder as well, just like some of the clauses we already mentioned. But we're focusing on how we can protect the founder of a startup. All right. So representation and warranties, we're saying the inventor will state that I committed myself. I'm saying it in layman phrase. I have committed myself for the period of 5 years, to contribute to so amount of investment amount in this business. All right, that is the part of the representation. Is stating that I actually committed myself to do it, or to doing something like this. The warranty is saying that where I fail to do this, I'm going to indemnify the founder in the situation of a loss and all of that. All right, so it's more or less like slightly, related to the indemnity clause. All right, so we also have the term sheet. So what the term sheet is saying is, the term sheet is generally not binding. All right, but there's an exception to that general rule. All right, so the term sheet is basically a summary, a summary of what you've negotiated. All right, it's in that term sheet that the agreement is made simple. Let's just say that agreement made simple. All the unclear terms that you've seen in the agreement, they are spelled out in simple words there. They are clearly explained. All right, such that there's no everything you need to understand is there. All right, so but generally it's not binding, but that's as a general rule. But the exception to this is that where it has to do with terms such as non-disclosure, exclusivity, and cost, these are binding. These are usually binding, on the investor, on the parties involved. All right. So, like I said, investors even know some of these things we just talked about. A lot of them, because they've done series of investments, they know all of these things. All right. And they might say, you know what, we are not going to. This agreement does not favor me. I'm not going to do. Maybe they might be insisting that they want to have up to 70% voting right, or 7 or a huge percent of equity in your business. And as a founder, that could be a red light on your part, because you could be like, you know what, if peradventure something happens that we didn't plan for, I'm going to lose this business to this investor. All right. So what we just say, we can only advise is that you move on. You move on to another investor that would, that you can have a consensus in terms of, agreements based on what you have in the agreement, in the investment agreement. And if it proves hard to find a credible investor, you can as well adopt other financing mechanisms, other financial options, financing options. All right, crowdfunding, those things are still there for you. All right, so you can choose to probably list your company or your startup in stock exchange, international stock exchange. the one within Nigeria, So what this does is that it prevents your business from being handled by one share investor that holds multiple percentage, of rights over that company. So in this situation, people can invest, different people can invest in that company. All right. So there are other financing options you can, adopt. But one thing you should not do is that because you need the money, and then you agree to someone actually taking 60%, 70%, in your business. And also, this thing has to be balanced, even though we're not talking about it from the perspective of an investor. That even as founders, of startups and all of that, it's important that we keep to our side of the agreement. Every representation we made, let's ensure we keep it. Like I said, it's a business. All right, it's more like a business, and both parties should profit in the best way they can. All right, so in all, I also mentioned something about the advisor, the advisory board. All right, you need your advisory board. If you can afford it, you might also need financial advisors, that would guide you in making the options you need in actually making or approaching investors, or how you can just get finances generally available to your business to make it scale. All right, so this will be all for this afternoon. Just like last week, we looked at all of these financing options. Today, we've also come from the angle of investments. We hope you've picked up one or two things. That's our pleasure that you're able to pick up. Maybe one thing stands out to you, or two things, and be able to apply all of these things. All right. So, like I said also earlier, we